The next case, or the first case today, is Dave for Scott. Each party shall have 50 minutes to present their argument. The appellant may reserve up to 5 minutes. You know how long you'd like to reserve at this point in time?
5 minutes, please.
Okay, very good. I'll be keeping track. You can look at it over there.
Beautiful.
And keep track if you wish as well. And I will, if you get close, let me know you're running.
Yeah, just give me a time. Thank you, Judge.
You're welcome. The arguments are being recorded. So when you come up, number one, it's important that you introduce yourself for the record. So that's on the recording. It's important that you stay behind the podium because that's where the recording's taking place. It's important that you speak loud so you can be heard. Judge Carr not being here today, please speak loud so she can hear that. If you need to use the name of any children, minors, victims during the argument, please make sure you refer to them by their initials or as a name like the victim or the child or something like that if you wish to do so for an identifying term for them. The judge has read your brief and we're ready to proceed when you are.
Thank you, Your Honor.
All right, thank you. Your Honor, Seneca Contouris on behalf of Appellant DeLawrence Scott. We did file a brief. I would request to reserve 5 minutes as we just briefly discussed. Hopefully Judge Carr will feel better soon. I've been suffering from the same thing myself. If I may proceed. Thank you. Excuse me, it really is there. On antibiotics, not contagious, so we're good. Several days now. All right, to start out with just a very brief summation of the statement of facts, and I would typically ask if you would like me to waive those. However, I think in the instant matter, based on the two dueling briefs as they are, the state took a very one-sided approach to the recitation of facts. Granted, that's their right to do. It's understandable. However, I think that it is key to this court's review because it's also key for the ultimate issues of sufficiency and manifest weight. In short, there was an altercation that occurred within the residence. Mr. Scott was there along with JD, the victim, Mr. Scott's girlfriend, an older woman who was a grandmother who was there, and there was an altercation that occurred inside. Now, ultimately, did it spark the tete-a-tete between the two? Of course it did, but it's also somewhat irrelevant because the true crux of the facts occurs once everyone is outside on the front porch. This is the point at which shots are fired. This is the point at which Mr. Scott's self-defense claim really comes to fruition. So what happens is inside there's an altercation between Scott and his girlfriend. JD comes in to break that up. Scott feels threatened, grabs his children, starts to move outside after calling his father to come and pick him up. And the aggravation continues as it was. However, there was separation. So that ended. It then moved to the front porch. Elder Scott, Lawrence, Mr. Scott's father, shows up. Scott takes his children, moves them out to the car. At that point, as he's moving them out, JD also has a firearm and is pointing it at Scott after issuing threatening statements. Right now, this is the part that is left out of the state's brief, is included in the appellant's brief, but does exist throughout the trial transcript. Some of this can be heard on a 911 recording, where the older woman, the grandmother, is heard saying they had guns, they, plural, multiple guns. It's also where, Mr. Scott indicates that he had a gun pointed at him, that he was to be pistol whipped, that JD threatened to kill him. And while some of these things are taken from Scott's own trial testimony, it's also corroborated further on, and we'll discuss it a bit more, by the forensic pathologist, by Detective Brown, who was involved, by other independent sources who acknowledged that that truly could have been the case. Okay, so that's essentially the difference in the facts. What occurs is on the front stoop, they come out, Scott puts his children in the car and feels threatened because JD is behind his grandmother, pointing a gun downrange at Scott, or down the driveway at Scott, I should say. And that's when shots are fired. Scott still feels threatened. He shoots in return. Unfortunately, one of those shots catches JD, and it's a fatal blow. runs off, Lawrence follows him, he gets in the car, they take off. Okay. So those are those pieces, and I just wanted to highlight it because I do think that it makes a significant difference in this court's consideration of the briefs. Now, with respect to issues 1 and 2 in our brief, they both are premised on these additional firearms that are found at a house in Cleveland where Scott is purported to be staying. A motion limine was filed, asking for their exclusion. Ruling on that was held in abeyance, as is typical. It was considered, it was not ruled on. At trial, testimony is adduced that indicates that there were additional guns found. Now, I understand from 2 sides, there's a motion limine that's not ruled on. Without a contemporaneous objection made at trial, that presents a problem. For the defense, it does. It could be trial tactic, and at the same time, it could be ineffective assistance of counsel. Now, ultimately, in reading the state's reply to our brief, they say, well, these facts were more helpful because it showed that these were not his guns. He had nothing to do with them. While that is true, that they were not his guns and he had nothing to do with them, it's not really helpful. Because we're here about a case that involves a shooting death of an individual. More talk about more guns around the defendant, it can never be a good thing.
Were either of the guns used, the type of gun that was used in this case?
No, they were both actually determined to not have been used in this case.
Well, they weren't used, but I was curious.
Were they?
Okay, so they did not, they were able to determine this type of gun was such and such gun was used here, and these were not the same type of gun. Do we call for the record?
I do not recall specifically, so I apologize, I'm not going to mislead the court by making something up.
No.
I do know that they were determined specifically to not have been used, whether or not they were a type or kind. I know they were pistols. In that consideration, they were the same. It was, there were pistols that were used. In terms of, was it a Ruger 9mm or a Glock or something like that, I don't know. I would ask the court to review the record, or I can supplement and ask you.
No, that's fine, we'll review the record. Thank
Okay, thank you. But again, to exactly that point, right, this perpetuates the confusion. There are guns, they are pistols, they're here, he's around them. He must be the bad guy with the gun that goes around shooting you. Like, this is the cumulative effect of these. And based on that, I think that it was improper for the court to allow the testimony or to not grant the motion limiting in the first place. And then it was ineffective on behalf of trial counsel to not contemporaneously object when this started. Further, and I don't know that there's case law supporting or unsupporting, if that's a word, this fact, but the fact that failing to present a contemporaneous objection limits this court to a plain error review standard is a problem. Because knowing in a case such as a murder case that will almost always go up on appeal by right, to not provide every opportunity for abuse of discretion versus plain error is error on part of trial counsel. So on those bases.
Was there any instruction to the jury about other act evidence? Do you recall?
Again, I do not recall specifically.
And that's okay, we'll look and see.
Okay, thank you. I appreciate that as well. I would hope that there was. I know if there was not, I probably would have included that as an issue on review, just because this was one of the main issues in this case. But again, I don't specifically recall.
You have about 2 minutes left in your initial time here.
Okay.
But a quick question on your sufficiency and weight argument.
Yes.
Your sufficiency argument in the brief seemed to cite a number of facts that to me involve the self-defense
Yes.
argument. So is your sufficiency claim that Mr. Scott, based on Mr. Scott was acting in self-defense, and that's not why he's acting purposeful, or is it specifically there's no purpose? Okay.
Thank you. Yeah, that's exactly what I wanted to clarify for the court. The purpose behind his actions was a purpose in a self-defense capacity. So he was not purposefully acting aggressively as an attacker. He was acting in self-defense, and I think that carries through into the manifest weight as well, where ultimately the standard to overcome on a self-defense argument, which is an affirmative defense. However, the way that it has switched is it's now shifted the burden to the state to prove that it was not self-defense. And they need to do so by a reasonable doubt standard. While there was evidence presented on both sides, there was, to the sufficiency question, not sufficient evidence presented that he purposefully acted to kill not in self-defense. And therein is sort of the splitting of the hair of it, but it's a very specific, important one, because he has asserted the affirmative defense of self-defense. He has presented all of the reasons as to why he was not at fault in creating the situation that occurred on the front stoop. And he was in a bona fide belief of imminent danger of death or significant bodily harm, as he had a deadly weapon pointed at him by J.D. These are the underlying reasons that he presented all of this on a self-defense basis.
Yeah, you're going to do your rebuttal time basically now. Would you like
Yes.
to reserve the rest for rebuttal at this
I
point?
will save it for
Okay,
rebuttal.
very good, thank you.
Thank you.
Good morning. May it please the court, my name is Rick Raley, and I'm appearing today on behalf of Summit County Prosecutor Sherry Beth Walsh and the state of Ohio, the appellee. And of course, I'm here to ask that this court affirm the convictions in this matter. I will kind of leave the facts as they are. This court's aware from our statements of the facts. You have the primary facts ahead of you. I will say that the state does not latch on to the fact that the defendant has claimed that there is a gun that was in J.D.'s hands at the time of this incident. There is a stray remark in the 911 recording about they had guns. That person did not testify. The person who did testify who was present at that time was J.D.'s sister. She said she did not see J.D. with the gun. They didn't find a J.D. They did not find a gun on J.D. at the scene. They did not find a gun in that house. They did not find two different types of casings at the scene. So I think that there's a lack of corroboration on that point besides that stray remark. So I do not believe at this point that we can really say that there certainly was a second gun. Regardless though, going to directly in response to what we just heard from Mr. Contreras, I think the sufficiency argument's pretty clearly something that is not appropriately reviewed in this case because of the nature of this argument. The statute requires purpose to kill, purpose to cause the death of another. That is confessed to when you make a self-defense claim. That is a confession and avoidance defense. That's why the messenger says you have to look at that only under a manifest weight standard. Now, regardless, there is sufficient evidence here of cause to death, most notably because he admitted to it. There's evidence that the defendant initiated this physical altercation, that he walked fast towards JT's location at the time of the shooting, that he fired multiple gunshots. Before that shot on the 911 recording, you hear the defendant's father exclaiming, "Don't do it." And then, of course, once it's done, the defendant flees the scene and gloats, "I don't play." From all of that, I think that a jury certainly could have inferred there was purpose to kill.
And where is that evidence from? Just the sister, or are there non-family members present who confirm or who allegedly think it was that?
So the defendant fleeing the scene would be from a neighbor who testified to that. The father exclaiming before the shooting comes from the 911 call, and you'll be able to hear that. The fired multiple gunshots, we know that from the physical evidence. We know that one shot into the torso from the knee. Now, the defendant walking fast towards him, yes, that does come primarily.
Did the neighbor witness any part of that, or just him driving away?
It was really mostly about those facts at the end, yes. The actual shooting, yes, it does come primarily from the girlfriend. And, you know, the jury heard those dueling theories. And there's all kinds of case law about when we have dueling theories, the jury is in the best position to judge the credibility. This court has to defer to those determinations of credibility. And I'd ask that this court follow that continued guidance in this case. So really, when I would go back to the first two issues that are raised, I have mentioned that there are procedural issues, particularly with assignment of error 1. There is a waiver here above a plain error. I don't think it was appropriately argued, so it should just be entirely disregarded. Regardless, I mean, I don't think that evidence that they found guns in a house that the police affirmatively said, we attached this to other people, and we know that it was not involved in this crime. The only point of offering that evidence is to show there's investigative thoroughness. They were following all the possible leads that they could find. And the jury is entitled to know that that is what the police were doing. There is an indication, this goes to the ineffective assistance claim, that although there was not a written ruling, I think that there's an indication there was a discussion at sidebar where it was essentially communicated that that's going to be allowed in. And at that point, I think a trial lawyer, defense lawyer, is very well within his tactics, within his rights, in his strategy, to decide, I'm not going to object in front of these jurors, have it overruled, and then this minimal, not important evidence really comes in. So I think that's a reasonable trial tactic, especially with the due deference that we give to trial lawyers in reviewing for ineffective assistance. And ultimately, we go to, I see no impact on the outcome of the trial. All we know is that there are other guns that other people are attached to that are found at a house that he stayed in every once in a while.
Do you concede this is other act evidence that somehow implicates the character of the defendant in this case?
I wouldn't say it's even other acts of evidence. I don't think it has anything to do with the defendant, because they excluded him as a person who necessarily is even attached to the guns. If it was intended to offer some sort of other acts, there would have been a notice filed about that. So that's why I think it really goes down to investigative thoroughness. They were pursuing leads. They made sure that they crossed their T's and dotted their I's.
Do you know if there was another act evidence instruction in this case?
I do not know that. I doubt there would be, because there wouldn't have been a notice, but you know, I could be wrong about that. So I really think with our deferential standard under the ineffective assistance counsel, I don't see how we can say this would be to the point where you have to reverse a conviction. So unless there are further questions, I'd ask that you affirm the conviction judges.
Thank you.
Thank you.
And you have your full 5 minutes for rebuttal.
Thank you. You know, listening to what was just shared, I would concede that there were not two different types of casings that were found on scene because only one gun was fired. However, that does not preclude the existence or the threatening nature of someone else holding another gun pointing it at Mr. Scott. In fact, their own forensic pathologist offered testimony indicating that the position of JD as he was examined indicated that he very well could have been holding a gun. One was not found. Further,
How long, do we know from the record how long it was after 911 call and the shooting before the police arrived at the scene?
I do not know. I apologize. Further, however, what I do know is that the girlfriend indicated she had jumped back into the house before the shooting occurred, and so she could not see what happened. She actually indicated in her testimony that she did not see what happened, she just heard the shots.
And you would agree with the prosecutor's office, I take it, that there was no independent witness as to the shooting?
Correct.
A neighbor, anyone like that?
Agreed, only the people who testified, other than the grandmother who did not testify. And I believe she had some medical issues that, I don't know if that precluded her from testifying, but there were, she'd suffered a stroke previously. That was something that was indicated in testimony. Additionally, Detective Brown had indicated that the shots that were fired could have been fired as advancing, could also have been fired as retreating. There was no way to determine whether those shots were fired one way or the other, which would certainly, if they were fired as retreating, certainly would have supported the self-defense claim. Not that there's a duty to retreat anymore, but you know, further indication thereof. And then with respect to the plain error, you know, issues 1 and 2 should be disregarded. This court always has the opportunity, even sua sponte, if you see something in the record that is contrary to acceptable jurisprudence, to sua sponte assign plain error to an error. And based on that, I would ask that even under that standard, you consider the first and second issues. With that, I believe the balance of the arguments are contained within the brief. I would ask that you pay particular attention to the manifest weight argument as it relates to self-defense. Again, the differences in the facts presented by the state and defendant make up all the difference in the world, and there are corroborating facts from independent witnesses presented by the state. So thank you for your time and attention. If there are no further questions.
I do have one question about the 911 call and the voice that says they have guns.
Yes.
Can you tell me more about that?
Absolutely. So, I believe her name is Miss Edwards. She is a grandmother of JD. She is there, she refers to him as her son, but testimony was adduced that due to her stroke, she calls people different names. She's in the background, she is heard on the 911, they have guns, they have guns. When I believe it was the girlfriend was asked to identify whose voice that was, she identifies it as Miss Edwards, the grandmother. And it occurred as Miss Edwards is on, she was the one who called 911, so it was her call that was played.
But Ms. Edwards didn't testify.
She did not testify. And again, I do not know the reason why. I do know she had medical condition. Certainly hearing it directly from her would have been better than hearing a voice on the tape. However, it was pretty specific listening to the tape that it was multiple people or multiple guns. A pretty significant distinction. Does that answer your question?
Yes, yes, thank you.
Okay, you're welcome. Any other questions?
Thank you.
All right, thank you very much for your attention and questions.
Well, thank you both for your presentation. The court will take the matter under advisement and will issue a decision in due course. The decision will be mailed to you by the clerk of courts and also will be released to the High Supreme Court's website.
Thank you.
Thank you, judges.